So our next presentation, and just to close the morning, is on the issue of live export, which is a topic close to my close to my heart and to the RSPCA more broadly. Celeste Black is from the University of Sydney, Faculty of Law. She runs the Animal Law Unit in that faculty, and she has a background in law from both the United States and Australia, and I'd like to welcome Celeste.
Well, before my first slide comes up, I'll just say that I've been given the very challenging task. Jed asked if I would mind speaking about live export and also WTO law, which in and of themselves, each of those could fill up a whole day. So, do we need to escape? No, that's Jed's. So what I've decided to do in order to try to say something meaningful in the short amount of time that we've been given is to just, oh, you're seeing all my slides ahead of time, to just focus on two specific issues or aspects of live export. And I think that if there's time, there might be some room for some of the other issues to be addressed in the panel session later on, but just for the purposes of my presentation, it's just these two. So what I want to do is, today's presentation is to provide a bit of an overview, sort of as way of an update on what I now realize is called Scast for short, so the Exporter Supply Chain Assurance System. So what has happened to the new approach that was designed in response, great. So to provide a bit of an overview about how that has been incorporated, okay, thank you, into the law and how it's been extended out beyond cattle exports to Indonesia across the live export markets more broadly. That's still in the final stages of rollout. And looking a bit at the roles of the independent auditing system that's been built in. And there's a little bit of data coming through on non-compliances, and I probably don't have time, but it's also interesting to look at the, I suppose, with whatever system we have, it always depends on how well it's managed and monitored and how compliance can be judged. So we'll comment on that. I think one thing about information, there's been a few people who've commented on difficulty in finding information about what's going on. I think in perhaps with respect to the Scast, if you go onto the website, there's an abundance of information. I was commenting in the break to Philip, to some extent, there's so much thrown on the website that it's not necessarily meaningful information now, where the various audit reports are all put online, but with so much information blotted out that it's not necessarily of much use. I mean, you know that they're being done, but how much value that has. But the other half is other half of the presentation is to try to have a look at a little bit at the WTO law with respect to restrictions on exports, because we do hear from time to time, not necessarily, I don't want to say excuses, but reasons that we are to some extent restricted in what we can do because of WTO law. And so I wanted to spend a little bit of time just highlighting some of the issues that may arise on export restrictions and free trade law as a way of introducing those issues. But again, they're quite complex, and to deal with them properly would take much longer. Hopefully, when the papers do eventually come out, they'll be available, so anyone who's interested can follow up on the details then. So okay. So just to start out, the Scast system. So again, this is all that I'm going to be looking at from the live export part, and then how this system has been designed, perhaps in light of trade restrictions. So the legal framework that we have, because obviously these are activities we're looking at control once the animals have reached their port of arrival, once they are taken off the ships, that it's outside the jurisdiction of the Australian government. So direct regulation, direct control is not an option. So as a way to indirectly provide some degree of control over the process, as seemingly the compromise situation is through the conditions attached to the licenses that the exporters must receive in order to load the animals on board and take them overseas. So the way that the version of the rules that actually incorporate Scast across all of the live export markets is through those various acts, which I won't read, but it's built into both the export licensing system and the export permit system. So the exporter must hold a license and must also have a permit with respect to a particular shipment. So through the measures listed there, the new control supply chain system has been incorporated into the legislation through the details come in that final bit at the bottom, the export control animals order, which was amended in February of this year, which provides for the broader extension. So now the Indonesian specific order is no longer required. And so that's just how it actually fits into the legal framework. So just to highlight a couple of the main parts of, so these were the new clauses that were added into the export control order to deal with the live export of animals. The Secretary must approve the supply chain as part of issuing of the export permit. So it's part of the process that leads to the permit being issued with respect to a particular export, and also it's a condition that with the license more generally. But when you read through the rules, those of you who've looked at the live export regulations, there's various stages that an exporter must work through, different, the notice of intention stage and the risk management crimp for short stage. And the Scast must also be approved in advance, so the destination supply chain must be an approved one before the export permit is provided. Now, the content of the Scast is, I suppose, what we're interested in. What is it actually focusing on? And it has a number of main issues that must be dealt with within the Scast that's put up for approval. So it includes the issues about how the animals will be managed from up until and including the point of slaughter, the tracking, so the ability to track animals. So this focus, which still persists on Australian animals, being the animals that we're concerned with for the purposes of the licensing, and the independent auditing role. So the mechanism to provide for independent and competent auditors to inspect and sign off on the supply chain prior to the animals first being exported, and then the follow-up audit process that occurs after that. And to build in that final clause there, to link in the OIE recommendations, so the World Organization of Animal Health, those are built through the handling of livestock, which includes up to and including the point of slaughter, will be that you have to be, the Secretary has to be satisfied that they will be in accordance with the OIE recommendations, which is what the initial independent audit should be able to certify. But there are other matters in approving an Scast, not only the particular audit report, but the particular exporter's record in the past of adherence to approved Scasts, if we can say that, and compliance with any other conditions that might have been applied to previous permits or licenses. And the permits, of course, can include additional conditions if the Secretary takes the view that that is important. There's other rules about adjusting, revoking, amending Scasts. What's actually included in the Scast, the sort of the broad categories of information or the issues that need to be addressed are included within the export order, but in large part the details about what needs to go into an Scast is provided on the website. It's through recommendations that came out of the farmer review, and then details that were elaborated on by the Industry Government Working Group, which did 2 reports, one on cattle and buffalo and one on sheep and goats, that have expanded upon and elaborated what these different things would mean, and then these approaches have been adopted and can be found on the DAF website if you look for Scast. So the emphasis are of those 4 things. So the control of the supply chain, that the exporter must have either direct control through ownership or control contractually over the entirety of the supply chain. The traceability of animals, that you can actually track to see, and this has been an issue with investigations and reviews of footage that have been provided to the department, identifying are they actually Australian animals, because the rules only apply to the Australian animals, so they try to identify from ear tags, what have you. There is a particular problem, I understand, with respect to traceability of sheep, because unlike cattle, there's not the individual identification in relation to sheep that we have. So they're working on ways to be able to identify which are the Australian sheep and which are the non-Australian sheep, which I understand is quite a challenge. So that's an issue, but they are working on ways to be able to work through that. The independent auditing to ensure compliance with the OIE standards, where there's the detailed checklists, which I have an example from, where the OIE guidelines have been used as a starting point to develop a very detailed set of checklists that an auditor can use when undertaking the auditing of the supply chain, as well as for the establishment of the approved supply chain, and then the follow-up audits as well, to assure that those standards are being met. And then the reporting and accountability, the reporting back, the provision of those reports back to the department, back to DAF, and where, as I mentioned, there's a large volume of de-identified reports that are available online now if you are interested in having a look. So the guidance, there's the DAF checklist for the assessment of the SCAS. It's not prescribed that you must use this, but it's put forward as a suggested way that you could be shown to have met the auditing requirements with respect to the welfare issues. This is based significantly or substantially on the IGW, the Industry Government Working Group reports, the checklist that were put together at that point. So we talk a lot, or we've mentioned, or most of you have referred to the OID recommendations. I actually went back to the OIE code to see what term they use, standards, guidelines, recommendations. They use the term recommendations in the code. So we've heard mention of the World Organization for Animal Health, which was originally established focusing more on animal health in the context of disease control. But with the acknowledgement that part of health is welfare. And so Chapter 7.5 of the Terrestrial Animal Health Code relates specifically to slaughter. So, and there's a fairly detailed set of recommendations where it does deal with stunned, pre-stun slaughter and slaughter without stunning. But I just thought, by way of an example, if it's not something that you've had time or interest to actually look at the checklist, they are available online, but one example I just pulled out to see how these things work out. Supply chain element 6 deals with assessing slaughter without stunning, and there's a list of performance outcomes. In this case, you can read that animals are presented for slaughter without being unduly stressed, and then there's particular criteria that the auditor is asked to look at in the context and to tick off whether compliance or it's is being met, whether that standard is being met or not. So you can see the auditor is asked to observe 10 animals or 20% of the daily slaughter, whichever is less, so it can actually be quite a few animals that would necessarily need to be observed, and that there would be, well, you can read those. I mean, I think what's interesting is that a target of less than 3%, I mean, I'm no mathematician, but 3% of 10 is less than one animal, right? So there can't really be less than one. So you would have to assume that the target is that no animals are vocalized prior to restraint. Otherwise, you would necessarily meet that 3%. I should say, in the guidelines, in the checklist, there are references. So there's a lot of, there's a few references to the work of Temple Grandin. And I think that one of the issues that she had identified early on was the clanging and banging and the movement of people. So that's where some of these additional measures are coming from. So there's a lot of detail in those checklists, which are provided as a way to assist exporters to meet their auditing requirements. So whether the auditing requirements need to address the OIE recommendations, whether the supply chain will meet them and is meeting them, and the issue of control of the supply chain and traceability. And so as part of the approval of a new SCAS, all types of animals that are being exported, so cattle, buffalo, sheep and goats, have to have a pre-commencement audit for the approval of a new supply chain, and then performance audits will follow thereafter. And so again, this is not included within the follow-up audits. It's not included within the order itself, but through the department website based on the working group reports. So the approach that has been taken, it is, I suppose, all a performance risk management issue, is that with respect to cattle and buffalo, that there will be a performance audit report for the first 5 consignments, and then based on the reports that are coming back to DAF, there'll be a decision made thereafter about the frequency of follow-up audits. And then with sheep and goats, the standard that's been put online is performance audits, as you can see, for every 2 months for the first 6 months, and then again as determined by DAF thereafter. But with an additional suggestion that with at least 3 times a year that there would be more auditing during the higher risk periods with respect to sheep, which tends to be at the festival times where there's a greater risk, particularly of animals leaving the supply chain. I mean, that's one of the big issues with sheep. And there's no end of processing reports with respect to sheep. And stressing throughout the website that the auditing must be both independent and competent. So there are guidelines about how, under what sort of certification bases one could be confident that the auditors are competent to actually undertake the audits. Compliance issues, because again these are operations that are occurring entirely in a foreign jurisdiction, the Australian government wouldn't have any basis to conduct their own inspections. So the reliance is on the reports that are coming back to the department from the auditing process, as well as third parties. And so one, of course, interesting case that's come out of these very early stages of the process is the issues that were raised with the department from Animals Australia that then led to a full investigation looking at issues of non-compliance, and I'll get to that briefly with the time, and I'm completely running out of time. Online, there is a list of various things that the department can do if there's non-compliance with either the SCAS or a condition that's been attached to the export permit, and that's just listed there. There are non-compliance statistics that are going up online, and those are updated. So far, there's been no critical non-compliance reported. There have been 3 major. It so happens that 2 of the 3 arose out of the investigation that was initiated as a result of the Animals Australia investigation, where, in fact, the report that's online concluded that though the non-compliances were all categorized as minor, except for perhaps one instance, and that, again, is a judgment call what's major and minor. As a whole, given that only in the cases of the 2 abattoirs that did raise non-compliance issues, that only 4 animals were actually viewed, and a significant number of non-compliances arose with respect to only those few animals that were actually observed. It showed that indicated a systematic loss of control over animal welfare with respect to those abattoirs. And one thing that I think is quite important going forward with this approach is that the audits had not detected any problems. So the fact that the preliminary audits and the follow-ups had not detected any problems with animal welfare compliance. And I'm going to have to, in my very short time, the export restrictions in WTO law. The reason why I think it's important is because, I mean, trade law is, of course, relevant, and we see statements like this that are not usually elaborated on, but perhaps when we look deeper into the trade law, there might be some explanation why elements of the scheme have been set up in a particular way, because there is a recognition that there are certain limits to what Australia may or may perhaps not restrictions on what you necessarily can do, because a lot of WTO law is uncertain, but there's a level of risk in undertaking a particular view because it may give rise to a dispute with the WTO. So that, if I can just highlight some of the points from that. So the export restrictions are not generally permitted under WTO law, but it may be necessary to protect morals or Australian morals or the health of Australian animals, that we cannot discriminate, that we have to adopt the least restrictive trade measures that are available to reach our required goals, and then that we have to base our framework on internationally agreed standards as opposed to Australian standards, which came up again in the government response in July, that we can't say that because of trade law we can't require stunning. So just in brief, I pulled out and sort of just pulled out the language with respect to exports in the General Agreement on Tariffs and Trade. So Article 10 requires that trade regulations, which would include restrictions on or requirements in relation to the issuing of export permits and export licenses, they must be administered in a uniform, impartial, and reasonable manner, and they also need to be publicized, so that may explain the level of detail provided on the DAF website. Article 11 is where most of the issues arise, the quantitative restrictions rule. Again, just the abbreviated out of a much longer article, that there may not be no prohibitions or restrictions that are made effective through export licenses. They shall not be instituted or maintained on the exportation of any product destined for the territory of any other contracting party. And the non-discrimination in Article 13, which does include that reference to like products, which those of you who looked at WTO law on the import side know that like products is quite important. And I think that may be in part why, especially with the non-discrimination article, that the Scast system has been rolled out across all markets rather than it being only applied to certain markets like Indonesia, and that it also has been, it could be a reason why it's been extended to sheep and goats, because they would arguably be considered like products to cattle. And so you can't have a whole set of rules applying to one and not the other without running that risk that it could be argued that you're not in compliance. However, the export restrictions, the extra requirements to receive the license or the permit could be seen as a quantitative restriction in any event. So we could be seen to have violated that. I will skip over that to get to the general exceptions. So even though you may have a set of export restrictions that would otherwise potentially violate one of the articles to GATT, there is the Article 20 general exceptions that one may still be allowed to maintain those trade rules because you can justify them effectively. And in areas of WTO law, there's not a huge amount of authority. There's very little on exports. So a lot of the elaboration or discussion of the general exceptions have been import restrictions rather than exports. But there's two parts to that. You have to fall within one of the exceptions that's listed, and you also need to justify your measures under the chapeau of the article, which is the two conditions that I've listed there. That there's no arbitrary or unjustifiable discrimination between countries, again, that discrimination, and that it's not a disguised restriction on international trade, which usually been the case on export restrictions. The few cases that have come up and there have been a few, there's only been about 4, is that the argument has been made that exports are being restricted as a way to provide a benefit to your domestic producers. So by not allowing products to be exported, you're effectively keeping the prices down for your domestic downstream producers. And in that way, it's, and you're impeding the trade, the exports of those materials or items that will be used by the importing countries to do their further levels of production there. So there was a case around exporting fish, and what it was requiring that the fish be processed before it was allowed to be exported. That is not the issue here within our rules, but it's interesting to see the sort of perspective that the export restriction cases come from. But you need to fit in with the exceptions. So the 2 obvious ones that would be relevant here would say we are justifying our restriction on issuing of export permits because we consider it necessary to protect public morals. Right, that seems to be the most obvious one, but the alternative, which, as I mentioned in that quote from the report, is that whether it's necessary to protect human, animal, or plant life or health, looking at the welfare implications for the cattle and sheep involved. And public morals would seemingly be quite broad enough to encompass the general community's concerns about animal welfare. One requirement for both of those is that it must be necessary, the measure, so it must be the least trade restrictive option available. So that often has required countries to be less strict or more flexible in allowing arrangements to be negotiated with particular trade partners in determining licensing systems, for example. There is an extraterritoriality issue that does arise in all of these cases with respect to protection of morals, protection of health. The problem is that we're protecting animal life or health, where technically they're not Australian animals anymore. They just happen to have been in Australia when they were raised. So arguably, is it appropriate for Australian trade measures to be protecting animals that are owned and are in a different place? And the issue around public morals, which has yet to be tested, and this may come out of the sealed product ban, is whether you can have an affront to public morals based on what's happening outside of your jurisdiction. So can Australian morals be, and that's the extraterritoriality problem. Whether that's really a problem, Peter Stevenson has written a lot on extraterritoriality. The EU sealed product ban may give us the first opportunity to have the public morals issue addressed, to see is a legitimate public moral animal welfare, because that's the basis of that ban is welfare considerations. And I have to finish up, and I do apologize, but I did want to mention the technical barriers to trade, because GATT is not the only agreement. There's also the agreement on agriculture, which can have implications. But this is the most obvious place that one sees a reference to the use of international standards. So the argument that we have to use OIE guidelines, that we can't use Australian standards. The one threshold issue is that the licensing requirements are technical regulations. But if we, and there's the definition is in the annex, if we accepted that they are, then the regulation should not create obstacles to trade. And you can see the Article 2.4, that the country must use relevant international standards unless it would be ineffective in fulfilling the legitimate objective, where legitimate objectives can include inter alia, so it includes more broadly the protection of animal life or health. So that was the most obvious place that I could see the argument to say that under WTO law we have to use OIE standards could perhaps be coming from the technical barriers to trade agreement, where we have that reliance that that it's trying to encourage the development of internationally accepted standards rather than countries all developing their own, and that effectively creating further barriers to trade as a result. Oh, my thank you slide's not there. Okay. I said so apologize for the pace, but thank you for your attention.
I think if you don't mind missing a tiny bit of your lunch break, we do have time for a couple of questions, if there are some. Yeah, at the front.
Celeste Green McEwen, Barrister Summer Welfare Panel. You mentioned the Farmer Review's emphasis on independent auditing requirements to secure compliance with OIE standards. Who pays the auditors? Is it the exporter?
The exporter.
Another question? Okay, well, since we are a little bit over time, we'll wrap it up there. I just wanted to thank Celeste and all the other speakers in this session.